Any mention?
May we please, Your Lordship?
Yes.
Your Lordship, I beg to make a mention for item number 5, Your Lordship.
Item number?
5.
Yes.
Your Lordship, I pray for 4 weeks' time, Your Lordship.
Why?
Your Lordship, actually, what happened? Earlier, I took time joint prayer.
The contentment
for the board to place it. It is placed in the board, but board could not be set, so it will be sitting the last week of August or first week of September. Therefore, 4 weeks time. In fact, KP is not here.
Okay, just say at the request made. There are only you are applying for all the respondents.
All right.
And the request made in behalf of the respondents. This is matter of 4 weeks.
4 weeks.
Yes.
Much over.
Please inform the petitioner.
I'll inform.
May it please, Your Lordship. Lordship, I beg to make a mention of item number 7, Your Lordship.
Yes.
Lordship, I pray if this matter may be listed after 3 weeks, Your Lordship.
Yes.
No objection, Lordship.
You are making mention on behalf of Majika, Dr. Majika.
Yes, Your Lordship.
Just have the request made on behalf of Dr. Majika, Lanet. BSG appearing for the respondents. List is matter for 3 weeks. Yes.
Highly obliged, Your Lordship.
May I please, Your Lordship? I beg to mention item number 8, Your Lordship. If the matter may come up after 2 weeks.
Objection. This is a criminal appeal.
Yes.
Yes, Your Lordship.
2022.
Yes, Your
Do you
Lordship.
have any interim order?
We don't have interim.
The appellant is in jail.
I am not
Is he-
sure, Your Lordship.
Okay. 2 weeks at the request of the appellant. Yes.
Much obliged, Your Lordship.
It's a list
May
of
it please, Your Lordship, I beg to mention item 4, if this
Yes.
matter can come up after 2 weeks. Item 4.
This matter, Lordship, they have been taking adjournment repeatedly, Lordship.
There is an interim
Underground.
order. There is an interim order here.
Interim order is there, Lordship.
The suspension is
Suspension of the sentence. They have been taking adjournment repeatedly on the ground that they are doing some research.
yes, madam. What is the purpose? What you will gain by doing that?
This is that visa matter, Lordship.
Okay.
That
is
matter,
also-
that issue is there. Whether
Yes,
it can
yes.
be retrospectively
Yes.
extended or not. That is the only issue.
Why?
We need time, Your Lordship.
Hmm?
We need time, Your Lordship.
We've been given enough time. Tell Mr. Gurung that this court will not give any further time.
Yes, Your Lordship.
Just we'll give him time today and then we'll just see. This also number 8 at the request of the petitioner. This is matter after 2 weeks.
Obliged.
Much obliged.
Lord, item number 15, my lord, if this matter can come up after 2 weeks, my lord.
Yes. Who is the other side?
No objection,
No
Your
objection.
Lordship.
2 weeks at the request. Yes.
Obliged.
Obliged, Lordship.
May it please, Your Lordship. Lordship, on joint request, we beg to mention item number 6.
Yes.
This matter may be taken up after 2 weeks, my lord. And for the private respondent number 4 and 5.
Just say
I'm
joint
appealing on
request has
behalf
been
of
made.
respondent 1, 2, 3.
Just say the joint request has been made by the parties to adjourn the matter for 2 weeks. Accordingly, this is matter for 2 weeks. Yes. Yes.
May I
Lordship,
please,
also,
Your Lordship? I beg to mention item number 2, Your Lordship.
Item number?
Item number 2. I'm appearing on behalf of respondent 1, 2, 3.
Yes.
I'm praying for 2 weeks time, Your Lordship.
Why?
Due to some personal
2017 matter.
difficulties. Yes, sir.
Yes, Mr. Sangma.
Lordship, here I am the private respondent, Lordship. This
You
matter
are
has been
petitioner,
keep
Mr.
on,
Ajay.
I am the petitioner.
this has been keep on adjourning for many times, Lordship, either by the parties.
So you also have objection to the prayer of the respondent.
Yes, I am objecting because short time maybe because 2 weeks.
This is a decision of the district council.
Yes.
So they become essential party. Yes, Mr. Hajarika.
Yes, it may be given 1 week time, my lord.
You are praying for 1 week.
I'm praying for 2 weeks time.
We'll give them 2 weeks and then we'll
Oh, yes,
see
ma'am.
this old matters court is not very much inclined to adjourn. So please make sure that we take up the matters. Yes, a request has been made on behalf of the respondent number
1, 2, 3.
1, 2, and 3.
to adjourn the matter. The Mr. P.T. Sangwan Learned Counsel appearing for the respondent number
5.
4 and 5.
4 and 5.
has raised objection, has objected to the prayer of grant of adjournment. Stop. However, Mr. Hajarika Learned Counsel for the petitioner has no objection to the prayer made. Accordingly, this matter. Accordingly, the prayer for adjournment is allowed. List after 2 weeks. Yes.
Similar prayer for item number 13 and 14.
Your Lordship, item number 13 and 14 I am paying for the private respondent.
Yes.
My lord, no objection for the adjournment.
13, 14 at the request of the petitioner when?
After 2 weeks, Your Lordship.
At the request of the petitioner, list of parties.
Obliged, Lordship.
Deeply
On the other
obliged.
side, I beg to mention item number 16.
Lordship, I'm appearing for the private respondent number 4 in
16,
this
17
matter.
and 18 are connected matters, my lord. These matters may be kindly taken up after 2 weeks, my lord.
Yes.
Lordship, no objection. After 2 weeks.
16, 17, 18 also. Yes, sir. List after 2 weeks at the request of the petitioner. Yes.
Deeply obliged, Lordship.
May it please your lordship.
Yes.
I beg to mention item 10, 11, and 12. Connected matters.
Item 10, 11, and 12.
I don't have much to say.
Yes. What happened?
Lordship, I'm praying for 2 weeks time.
These are petition for quashing.
Yes, lordship.
Quashing of what case?
Regarding the FIR lodge against the petitioner.
FIR? What is the allegation?
Misappropriation of funds.
Misappropriation of fund. Very serious allegation. To the tune of?
Lordship,
To the tune of how much? How much money you have misappropriated?
I have no knowledge, lordship.
Not countable, non-countable. Yes, Mr. Shulai.
Very good, lordship.
Yes, this also. After 2 weeks of the request. There is no interim order, isn't it?
No, there is
Yes.
no.
How do you pledge?
Yes.
May I please your lordship? I beg
Yeah.
to mention item number 20.
Yes.
I pray for 2 weeks time
Why?
because the similar matter is going on in DB, Your Honor.
That is.
Lordship,
We'll have it after 3 weeks then.
after 4 weeks. Now after 4 weeks.
Well, let's do it for 3 weeks. After 3 weeks, at the request of the petitioner.
Obliged.
Supplementary costless, item number 1.
Yes, what is this?
But this is the application seeking for some interim protection to the accused applicant.
What is the matter?
Well, this is we filed a regular bail application.
Why bail is here before this court? Before this
Well,
bench?
what happened in this case? We filed a regular pre-arrest bail application before the court room
why
number 3.
bail application is before this court?
No, my lord, I'll come, my lord.
Yes.
I'll come. Last week, we filed a pre-arrest bail application before the court room number 3, who has the roster in his hand. And when the matter came up, the Honorable Court informed the parties that the issue as to whether the CRPC or CRPC will continue to apply or PNS will apply. So that issue has been seized by the division bench. So because of that, he could not proceed. However, liberty was given to us to make a mention if necessary. So we made a mention before the division bench yesterday. And the division bench, appreciating the urgency, allowed for listing the matter. However, the bench would not be available. The bench would be available before just comprising Justice Tindo and Justice P. Bhattacharjee. So we came to registry, and
so it was mentioned before us at
yes,
that point of time.
Yes. And therefore, Lordship court has matter is endorsed to my lord for interim protection. My lord. Only the main application is still pending before the court room number 3. So, my lord, if the main application, my lord.
This is an application under 438.
438. Yeah, my lord,
now, what is the plea taken by the state that it should be under the new?
My lord, they did not take any plea, but only, my lord, the issue is seized by the Honorable Division Bench.
No, but then why you are raising this issue?
But in fact, we are not raising, but the court, my lord, put that question. So, shown some disinclination to consider at that stage. So, I prayed for some protection, because after all, CRPC or PNSS relates to procedural law.
What is your stand? You maintain that 438?
My lord, under the CRPC, my lord, since the FIR was lodged under the All Act, yes. Investigation launched under the All Act, and now they are.
Anyway, right now we are not on those.
Yes, that issue is not there, my lord. So I humbly pray, my lord.
Bail application has come up before this court because the bench is not available today. Other bench is not.
Yes. Now the main bail application would be listed on 14. So
yes,
till 14, my lord.
What is the FIR? Where is the FIR?
My lord, that.
Mr. Khan, any objection against any interim prayer?
Worship, it's not exactly objection, but we have a situation. So let him finish. I'll
Oh, this is a transit bail application.
A transit period.
Case is registered somewhere.
My lord, in Dishpur in Guwahati, under section 406 and 420.
Yes. So why Tezpur you have given transit? Guwahati is very near to you.
Now, what the problem here is, the present applicant also filed. In fact, he placed an order for top model Verna in Guwahati last year. Now, when he went there to receive the vehicle, the showroom delivered second model and asked him to return the next day for replacement. So he returned on the next day itself and asked for replacement. They said, no, you keep the car here for some time, we will replace it accordingly. So he came back to Shillong, and what happened? After a few days, they have sold that very car to a third party.
Very car means the car which you returned.
Which I played. Third party.
Which you returned.
In which I
but
returned.
Then you are not claiming it.
Now the problem, my lord, all the vehicle number is transferred in my name. I availed the loan, and the loan is also standing against that very vehicle.
No,
now the third party has.
For availing loan, I don't think it can transfer.
My lord, that also, my lord.
Only you avail before the vehicle comes. Transfer.
My lord, before he deliver a part payment, and he availed the loan, and he made a complete payment. Now, in view of that, now third party has taken over, and third party is pressurizing him that you transfer all the requisite documents. Now, that pressure, my lord, he has filed a FIR in Dishpur against the sales manager and the other party, and the police register a case there in Guwahati and summoned the party. And
how your vehicle could be sold by somebody if you are the owner?
My lord,
if the vehicle stands in your name,
my lord,
how it could be sold by?
That is why, my lord. That is why I filed register against the sale manager. Without my consent, he transferred.
You filed FIR?
Yeah, I filed FIR in Dishpur. In Dishpur. Police.
You filed FIR in Dishpur. Why?
Yeah, in Dishpur. Now the course of action arose there. My lord. The sale transactions,
vehicle delivered from Guwahati
only.
It back?
Yes, Guwahati only.
At Guwahati.
Guwahati only.
So why your FIR is in Tezpur?
Showroom is also in Guwahati. Now,
no, your FIR is in Tezpur. You filed FIR in Tezpur.
Yes. Now what happened? The police summoned those accused person and released him by executing upon in the police thana itself. Now thereafter, the purchaser of that very car came to Shillong and asked him to come to Shillong from Longstoin. He is from Longstoin. Prison applicant. He said I was busy, I cannot come to Shillong. He was threatening that if you don't come, your life is in danger. I will not spare you. So he filed another FIR in Longstoin, And no stone, my lord, no state police summoned that gentleman from Guwahati. He came there and visited the Thana and said that I am going to compromise with a very accused person here. So don't proceed against me. So the no stone police station will release them. Now thereafter now, in view of that pressure perhaps, the purchaser has filed another FIR, counter plus FIR in Guwahati, Deshpur, and Deshpur police commissioner issued the arrest warrant against me and hunting.
Arrest
warrant? Yes.
This case is under what section?
482, 420 and 406.
What is the punishment involved there?
My lord, this 420 is a non-compoundable.
What is the punishment? What is the?
It's 7 years above. 7 years.
41A is not applicable.
What?
Section 41A is not applicable.
My lord, it is not. It is which? It is not.
Why? What is the punishment?
Your lordship, can you see section 420?
420. What is the punishment?
It is 7 years above. 7 years imprisonment by recollect probably.
Yeah, so then 41A comes.
Madam?
How can you be arrested? 41A. Mr. Khan.
It is not 41A. They didn't mention 41A.
Is it not that 41A would apply?
No.
Is the case?
420.
They just simply mentioned 420.
What is that Anis Kumar judgment? See, you just cannot come up with this just because FIR is filed against you.
Imprisonment for 7 years and fine. Anis Kumar will be applicable.
41A is up to 7 years only.
7 years.
So there will be a notice applied to you. How can the warrant be issued there?
No. Well, they have issued a warrant. It is one.
How can?
Therefore, they came to.
There is a notice. 41A was issued against you. You did not comply.
No, there is no issuance of 41A. No notice was issued.
It sounds very unusual, Mr. Anyway, you see, we are not on merits.
Yes,
if it is a case registered
right,
now things,
right.
the actual aspect is none of our consideration.
Right.
The transit bail, I think the decision, there is a latest decision of Apex Court.
It is permissible. But only prayer, since it is a miscellaneous case.
What is that? Priya Indoria.
Right. It is there. But since bail application is coming up on 14, till then, my lord should give me some protection.
What are the requirement to be fulfilled there as per the Apex Court decision? Your proximity, the place.
My lord, if I recollect properly, the judgment says.
What prevented you from approaching the Guwahati High Court, which is very near?
No, now the problem here is, my lord, the police, Assam police.
See, you know the regard. It is not that this court should casually pass out of transit.
That is true.
Okay, just because state is not a party of this thing, so this Apex Court judgment, it basically casts some responsibility on the High Court or the court granting. Even the session court can grant, I think, probably transit. Right. Okay, but then certain things there has to be fulfillment of certain preconditions. So that is what is to be needed.
My lord, one of the criteria, if I recollect, by the Apex Court is that the applicant must show that there is a reasonable apprehension if he goes to a court of regular jurisdiction for moving bail application. In my case, my lord.
When this FIR was filed against
my lord, they did not disclose. We are not aware, but the case number is given.
You have not enclosed that FIR also.
My lord.
When this warrant was issued against you?
My lord, on 30th July.
And what is that thing? On what basis you say? What materials is there?
My lord, you can see my application. I made a detailed statement.
Only your statement?
Yes, my lord. If necessary, my lord, I will produce the warrant issue. Recently, after we filed this also, we received the warrant.
If you want interim protection, at least certain things should be here. And we have to issue notice. Assam is a party here.
Assam is a party, my lord.
And the law requires issuance of notice upon the public prosecutor and the investigating officer of that thing. The public prosecutor has not been made a party.
My lord, here it is in the investigation stage.
No, that is okay. Even for transit bill, you see, have you gone through the judgment, Mr. Shangresho? Of that Apex Court judgment, the latest judgment which you got to transit bill?
The latest judgment I'm yet to go through. I've seen once, but I did not have a complete reading.
I think, if I am not correct, Mr. Khan may have it there. It is state of Karnataka.
Priya versus state of Karnataka.
It is the latest, I think, 2024.
May I pray for tomorrow, my lord? We'll go through and place that judgment. We'll go through that judgment and place tomorrow, if possible.
That is all right. You see, yes, Mr. Khan. Any objection to the grant of interim proceeding?
Yes.
Why?
Lordship,
the objection. State has nothing to do here.
Lordship, the objection is not on On the merit part of it, the objection is, Lordship, the main issue whether the old act or the new act will be applicable, that's coming up on 14. So all the bail matters were taken up. Most of the issues that came up before the learned single judge on the issues of bail, learned single judge has rightly pointed out, saying that since the main issue is pending from before DVB, and he's also part of that division bench, and he said sitting singly, I can't take a view which may affect. So we had to we're giving the copy of the order which was supposed to be listed on 25th, but 25th July it was not listed, then again it's listed on 14. Because of the technical hitch, the learned single judge said, no, we cannot issue even notice, we can't give any protection, because giving protection would be submitting to either the old act or the new act. Now, in this case, Lordship, when
a person's personal liberty is in question,
yes,
whether those technicalities bar,
Lordship,
this issue will remain open.
Lordship is absolutely correct. That is exactly happened yesterday. Unfortunately, he could not get the matter listed before the division bench. A new division bench was constituted only for this purpose. And then we had agreed before the learned single judge, if it's a very urgent matter, kindly take a permission and let another DB be constituted only for this purpose, because the liberty is involved. And only for a limited purpose till the main matter is not heard, court can invoke 482, not 438, 482 say interim protection may be given. Unfortunately, the bus was missed yesterday. Now we are back to square one, where another learned single judge is hearing the matter. The judicial discipline that was a technical hitch before the learned single judge is the same issue now before your Lordship.
One thing is that if you take into consideration the facts involved in this case, it doesn't show involvement of any criminal intention here.
Lordship, absolutely correct.
There may be something
wrong. On facts, Lordship, I'm not saying anything. On facts, I'm not saying anything.
Now,
on facts,
a person doesn't have any criminal, intention in an act which has been committed by him. Is it not that he deserves some sort of protection?
Lordship, the protection is, Lordship, had I been arguing before any other division bench, I would have not even raised this issue. I would have said court can invoke 482 and grant something till the main matter is not heard. Now we have a situation, one single bench recusing itself, saying the matter is sub judice. He made an attempt yesterday before another division bench that could not be successful. Now again back to learned single judge.
Yesterday before division bench, this matter was mentioned.
Yes.
Made a mention. Bail application before a division bench.
Yes.
Made a mention.
Only
just because of that issue.
Only because of that issue. And Lordship, we considered when we were hearing the matter, we considered if it's very urgent. I agreed. I said, please, we agreed openly in the court. They kindly make a mention, file an application and get it listed before another division bench only for the purpose of till the matter is not heard till 13, you should get protection. Because another division bench can invoke 482. But now, Lordship, I leave it to your Lordship. Again, the matter is before a learned single judge. Then what do we do? How do we overcome that hurdle?
No, this will not, just because any interim order is passed at this stage by this court, it would not mean that the matter will stand seized by this court. It can go for this.
In Lordship, I leave it to your Lordship. But when another single bench has said, I will not, and he is consistently...
It is in some order passed.
No order, but there were more than 4-5 matters before the same learned single judge, and he repeatedly passed a consistent order. We are not going to pass any order till the matter is.
Mr. Shangresho, you wait till next week.
On merit, Lordship, I don't want to say anything because of judicial discipline. Otherwise, I leave it to the court. Lordship, kindly go.
That is what the problem is.
Yes, that is the only hitch. That's why I said. Otherwise, merit, Lordship, they can compromise. He may have a matter.
But that is on the basis of the prayer made by the parties.
Lordship, yes.
Because of the issue, pendency of the issue.
Absolutely. And then Lordship, I'll just apprise the court, Lordship. After that, what happened? There were few matters that came before the learned single.
See, we have raised the question of judicial property. I don't think that speaks about anything.
Yes.
That this doesn't say that the single bench should not take up the matter.
It doesn't say. It doesn't say.
So the question of propriety would not come.
No, Lordship, absolutely correct. So, I'm saying, Lordship, what had happened before the learned single judge, when the matter came up, it said, no, since I am also one of the part of it, and then we agreed, how do you find a way out? We agreed in the courtroom, we file a miss case and get it listed. No, it was again listed before a different division where the matter could not be taken up. We were waited for that matter to be taken up. And unfortunately, fortunately, now the matter is back again to a different single bench. So I leave it to the discretion of the court. If the court feels that it can pass an order, I will not be a party to it in saying whether this court should take up or not. because in view of this order.
That is not your submission. Just because if this court entertains any kind of interim prayer at this stage also, you would not mean this is the issue that whether the old act, new act.
That is not the issue. That is not the issue. Absolutely, absolutely. No issue in that.
See, even if we pass an interim order, we'll keep this thing open. There is no question.
Absolutely correct, Lordship.
Diluting.
But then, since the roster,
that the court is concerned about the personal liberty of a person who apparently doesn't seem to be involved in any.
Lordship will kindly see there is no.
What your mind would say that whether that kind of person needs protection or not.
Lordship, on merit, yes, but when it had been different division bench, I would have said 482 could be invoked. I would have assisted the court and saying it could be invoked. But in a situation like this, let him wait.
Another aspect, you have not made public prosecutor as a party.
And the main
Apex Court says.
And Lordship will kindly see para 6 of the petition. Lordship, kindly see the para 6. The main allegation is against respondent number 1 and 2, who happen to be the Guwahati test board. And PP has to be present. Even on merit.
See, if you see that this is not just check the decision that that is what is that that I think it is
latest judgment is
2020. It has been reported in 2024, Lordship, but
volume 4 to SCC. Now there Apex Court says that in a transit way, though the court has the power to pass interim order, but then the notice has to be issued to the
prosecutor,
officer involved in the FIR, officer and the public prosecutor involved in the FIR.
And the Lordship specific.
So that is what. But then you have not made public prosecutor.
My lord.
Lordship will come to para 9 page 6. Para 9 page 6.
He is a miscellaneous case.
The present petition. Specific pleading, Lordship. Page 6, para 9.
Yes.
Office got it?
Yes.
That when the accused person came to Shillong on 31st, the family members informed him over. Para 9. Sorry.
Yes.
That when the accused person came to Shillong on 31st July 2024, the family members informed him over the telephone that the police team from respondent number 1 and 2 visited his house again in search for his arrest, and therefore the family members informed the team that the accused is out of station, and hence the above police team returned away from the house of the accused. When the accused further inquired from respondent number 2, he was informed that the test pool so-and-so and the second so-and-so was registered against him by respondent number 2 on the basis of complaint filed by so-and-so. So let's say respondent number 1 and 2 is state of Assam.
Yes.
So even that,
I don't dispute.
No, even that, if you apply the Supreme Court judgment,
you have to apply the Supreme Court judgment.
And the Lordship,
you cannot see.
No, you cannot. Lordship, then the public prosecutor of Assam has to be made heard on this issue because a specific case.
But then, you see, he has to be made party.
I will be implemented. I will implement the party.
But then, just because you see that it is not required that before passing interim order he has to be given.
No, Lordship is correct. I am not into that, Lordship. I am only into that other issues which came out because from single bench to division bench back here, then we have a situation. At the best, Lordship is coming up on 13.
My lord, the submission of the EAG
31st July, Lordship.
Is
today
highly technical, my
lord. Oh, no. Yes. 31st July. Today is what date?
Today is 7th.
7th.
And see the communication that happened. He came to search and then went back and came back.
31st, 7th, he could have gone to that state and approached.
My lord, here he has a reasonable apprehension to go down to Guwahati.
Then how can it be? That is something, you see, your submission and law doesn't go together. See section 41A of CRPC.
That is also another aspect.
Which mandates issuance of notice.
7 years. Anish Kumar.
What is that? Anish Kumar.
Anish Kumar.
Anish Kumar's case.
My lord, my humble submission, that is a duty of the prosecution to issue notice to me. They fail. Straight away they issue the arrest warrant. Where the citizen will go.
You have not taken any plea in your case.
But after we frame this one, my lord, we received the further information that they have issued. I'll place that arrest warrant also.
It is not in your requirement that 41A has not been issued to you.
My lord, while bringing the impleadment, I'll clarify if that requires, my lord. But here, my lord, here.
That is a question of fact. There is no question of clarifying.
My lord, I'll come. May I submit, my lord. The procedural law, either CRPC or PNHS, is absolutely a handmaid of justice. And here, my lord, the citizen is my lord, before my lord.
By Apex Court, Anish Kumar's case.
My lord.
It speaks about the protection against arrest.
My lord. If I need to implead.
Now, but then your petition entirely silent is not
on that part. Yes.
Out there.
Yes.
Implead, my lord. My lord, I'll seek lordship liberty to implead the prosecutor.
And bring the warrant of arrest also.
Before impleadment, my lord, lordship has pointed out it doesn't prevent my Lord's discretion to keep protection.
That is
Although it
because of
is concerned with the liberty,
Sangreshwar.
the life and liberty of the citizen.
Whatever you have stated, we prima facie do not find any criminal intention attached to it.
Yes.
So that is why the reason the court wanted to protect you. But then if there is a serious technical bar, then again it's
My Lord, my due respect, my Lord, I am ready to
See, apart
cure
from
that
the
defect.
question of application of old CRPC and new CRPC,
That is a
well,
different
this
issue.
court may not be very much inclined to accept Mr.
Yeah, yeah,
Khan's.
absolutely, absolutely.
But then what about the making the prosecution party?
My Lord,
You should have gone through the judgment of the apex court, which makes it mental. See, because previously there were decisions by different high courts.
Different high courts in a different
conflicting
yes.
decisions and all.
This judgment has at least crystallized that part.
my Lord, I may be allowed to withdraw this application. I'll file the fresh application in pleading the prosecutor today itself.
That is better.
And Lordship
Please
allow
take
me
care
to
of
move
this and
tomorrow.
see those judgments and those things. And also see section 4. That is very better.
I'll make mention tomorrow morning.
You
with
see,
Lordship
it happens, Mr. Sangreshwar, but then if you have the opportunity to correct it, you correct it. It's better instead of, you see, landing up in so much of technicalities. Make it simplify the things. We'll give him liberty, Mr.
Absolutely not. Yes. And then if you can bring to the notice of the court even the warrant which he says will be issued.
You will oppose again.
No, I'm not opposing.
You will oppose again. Highly technical, man.
No, it's not about opposing.
Anyway, heard learned counsel for the parties. After arguing for some time, the learned senior counsel appearing for the applicant, isn't it?
Applicant, man. Applicant
Seeks permission to do this case with your liberty to file a fresh.
Well.
Paragraph. In view of the submission, this application stands dismissed on withdrawal with the liberty as proof. And in the miss case, you say in view of the order passed in miss case 84. This will be the earlier order in the main anticipatory application. And in miss case 84, you just say in view of the order passed in so and so. This application also stands disposed of.
Yes. Deeply obliged.
Daily costless, item number 1.
Yes.
My Lord, the central issue, the main issue involved in this petition on merits here now.
We are in WPC. There is only one WPC, 139.
Yes.
239.
Well, only one WPC.
How many writ petitions are there, Mr.?
My Lord, 90 out of 93 of them withdrawn.
See the volume of the file, you need the whole thing.
And interesting is, my Lord, my writ petition is, the state affidavit is thicker than my writ petition.
Here, just tell us about your pleaded case in the writ petition.
Now, my Lord, the central issue
Do not go here, there, just tell us.
Yes.
Let us first understand what is there in your writ petition, then we will come to the other things. What you have, what is your prayer in the writ petition?
Prayer in the writ petition, my Lord.
And what is the cause of action for filing the writ petition?
Yes, my Lord, my prayer in the writ petition is set aside the section 11 preliminary notification and section 19 declaration of the Right to Fair Compensation, Rehabilitation and Resettlement Act 2013 on the ground of non-adherence to section 15 and other provision of the act. That is one thing. Second prayer is set aside the letter issued by the District Council, JJDC, on the ground that the letter that was issued was adverse to me, and even my Lord, the Garo Hills Autonomous District Council Land Revenue Regulation Act did not specify ROW. These are the primary two issues involved in this writ petition, my Lord. And the factual part.
One is to section 15.
Yes.
Which makes that entire proceeding liable to be cost.
Yes, and I'll please the Supreme Court judgment.
Yes. Now this is one of the.
Yes, that is the main thing. And second is to set aside the letter issued by the Garo Hill District Council. And they did not file any affidavit. They have
Garo Hills
received.
District Council.
Yes, Garo Hills District Council.
What Garo Hills District Council has to do in this acquisition thing?
My lord, what happened in this case? The state government proposed to proceed for expansion of the single lane into 2 lane in Garo Hills. My lord. Now they conducted the survey, and the survey done by the social impact assessment returned with a clear finding that the existing width of the road 45 kilometers, is 4.75 meters. And the JICA, so-called the Japan, the sponsoring body from Japan, along in collaboration with India, they also conducted the survey. They came with the same finding that the existing width of the road, as of now National Highway 51, is 4.75. And therefore, it needs to enhance to 12 meters. 12 meters. So in that case, they have to acquire another 6 point something meters from the existing width of the road. Now, to achieve that purpose, they conduct a survey, and they could not expand the existing road. Now, therefore, when they need expansion, they need another lane. Now, when they do that one, they allow the district council, JDCC, to involve in this process of identifying and conducting survey.
Who allowed? The collector?
A collector. And the NHITCL. Now, then the issue of ROW came into being before the collector. So collector called the meeting, all the parties, district council, PWD, NHITCL, collector himself, revenue department, they sat together. And now the NHITCL came with the first mentioning that there is a ROW, right of way. And right of way is perhaps acquired by the PWD long time ago. So PWD needs to clarify this. So if it is already acquired and keep the land remain as a part of ROW, it is not required to acquire it.
Just a question of acquisition of ROW.
Yes.
Where from it comes? Now, this road
yes,
was in existence. What came before? Whether you came to be owner of the land?
Yes.
Before, or the road
yes,
was in existence?
No. We were the original owners for a long time.
Just tell us one thing. When this road was constructed,
well,
originally, was there any acquisition of land from?
Nothing. Well, what happened in those days, my lord? This was built up during Assam time. Okay. During Assam time.
Yes.
And the Assam handed over to Meghalaya. Meghalaya took over through PWD, and they make it as a single lane road. And there was no acquisition, no land compensation. They don't dispute also in the affidavit. And now
so the road was in existence?
It was in existence.
Okay, it coexisted together.
Yeah, coexist together.
Okay.
And my lord, later on, my lord, this state highway was declared as a national highway. National highway. Now, the moment this road is declared as a national highway, it is under the control of the Transport Ministry. Now, when they propose for further expansion from single lane, what the size of the road available is a single lane, and the single lane, as per the finding report, survey 2 reports, it says that the total width of the road is 4.75 meters. Now, in a road, my lord, carriageway, soldiers are there, my lord, where the vehicle flowing, this is called as a carriageway. My lord, just left and right hand side remaining few areas are there, this is called as soldiers. Now these shoulders. I'll place those shoulders. Now they measure this one and they say that this is 4.75 meters, and therefore this is not enough to accommodate the 2-lane expansion. Therefore, government need to, my lord, we need to go for 12 meters. 12 meters.
So further acquisition is needed.
Yeah, acquisition concern. Now
that 4.75.
Yes. We are not disputing.
That is including this ROW or not including?
My lord. No. That will include the existing one, my lord. Now what they have done?
No. Existing whatever it is. If there is a rule which says that 35 feet from the center of the road,
yes,
should be taken as ROW.
Yes.
And nobody should own that part of the land.
Right.
Now that 4.75, whether that included that entire ROW area also?
My lord, the existing one.
Or it is only the blacktopped area?
No. Including the ROW. The blacktop area is there, left and right, my lord. Some non-blacktop area, unpaved area is there. That includes.
So 4.75, according to you, is including ROW.
Existing ROW. Exactly. Exactly. Madam.
So yes. Okay.
And now that is the road, my lord. This is from here to here. This is the, my lord, the blacktop area may be here.
Yes.
And left and right, my lord, some pits may be there. Unpaved area, non-blacktopping area. Along with that, my lord, the existing is 4.75 meters. And now, therefore, the report say that they have to enlarge to 12 meters. Now, in that case, they have to acquire almost another 6.25 meters.
To make it 12.
To make it 12. Now, let us leave aside 4.7. Now, to get that 6.25 meters, what they have done, they conduct survey. And they say that the NHIDCL, they say that to reduce the cost of acquisition others, there is a ROW. And this 6 meters something, or the land beyond the existing 4.75, there is ROW. And that ROW, in the discussion headed by the collector.
According to them,
yes,
it means the ROW is beyond 4.75
yes,
meters.
Yes, that is what.
So that remains a disputed fact.
Yes. Now they do. They say that, so beyond 4.75, there is another land. This should fall under the ROW. Now, and they say that this ROW area beyond 4.7, this land might have been acquired by the PWD for long ago. So the PWD should clarify to the collector. So the collector asks the PWD that you clarify whether the land, so-called ROW beyond 4.7, was acquired by you or not. PWD replied that there is no record of acquisition. And now subsequently, they have written a letter to the district council that whether this called ROW need to be paid compensation to the landowners or not. So the district council wrote a letter to collector. It say that 35 feet from the center line, existing road, do not require for payment of compensation. Now the letter in the PATA issued by the authority also, council INX, they never say this ROW. When they issue PATA, they say that we conduct a survey and there is one clause 4, it says that 35 feet from the center line should not be utilized.
Yes, and there is a provision for that also. I think this court had dealt with that issue before in some other moment.
Yeah, I've seen that one.
This is not a similar fact here. That there was no acquisition proceeding in that matter.
No, my lord.
So here
there was an acquisition
here
proceeding.
It's a acquisition proceeding.
So even there was an acquisition proceeding. They were again claiming that they should be paid compensation for the ROW. So Lordships had ruled that ROW is a different issue altogether.
My lord, I've seen that judgment Lordship deliver that the petitioner, Mr. Hazarika, was the counsel for the petitioner. He did not ask for payment of compensation for the ROW.
Because he said that he is not owning the land.
Yes.
But then he is in possession.
He is in possession. He is not the owner. So he is not concerned with ROW. He is concerned with the compensation for his occupation. And Lordship is
the structures which are...
Yes, structure he erected. So may the end of them. Now here, therefore district council has written letter that the 35 feet from the center line will not be required to pay compensation. Now, that letter was issued by the district council. They said by deriving power from the Garfield District Council Land Revenue Regulation, which they adopted the Assam Land Revenue Regulation 1886. That was the letter. Now, when we go through those, I'll go through later. I'll invite my lordship there, invite lordship attention to that materials later on.
Just sorry to interrupt you, Mr. See, Mr. Sangrecho, now district council said that 35 feet from the center of the road is not required to be paid any compensation.
For compensation.
Now, you said that the 4.75 meter includes ROW.
Yes. Yes, that is
now, if say supposing we do not know what role district council has in calculation of the rate and all, but then if we just accept it, just would it mean that this ROW is beyond that 4.75 meters?
Yes, that is what the claim of the respondent now.
Now, it means that remains a disputed fact.
Well, now I'll come to that, my lord.
Then,
I'll
how
come
this
to that.
read code will
No, my lord. Therefore, lordship, I'm not inviting my lordship to determine, though the collector, if it has raised some issues that title and ownership required to be determined. I'll come to that point, my lord. I'm not inviting to determine the title of any parties. Here, primarily, therefore, it concerned with the procedural fairness that is inbuilt itself in the Land Acquisition Act is adhered to by the collector or not.
And what are those procedures?
Yes.
Fairness?
Yes. If they adhere to, I don't have a case. I have to go to collector, file appropriate application for enhancement, even disputing the area, measurement, whatever, an apportionment of compensation, whatever. But if the Lord satisfied finally that yes, inbuilt mandatory procedure has been flouted, violated by the collector, then Lordship may quash the entire proceedings. And I'll get the support of the authorities also. Therefore, I'm explaining the brief background that before I refer to the annexures and the law. Now, what happened after they received that letter from District Council? Now they measure what happened, madam. Before they issue Section 11, madam, interestingly, they received the letter from District Council, and that District Council letter has emboldened the collector and the NHIDCL. Yes, we don't need to spend a huge amount of money. We will measure this one, center line, 35 feet. So when they do that one, total one from 35, it comes to about, my lord, nearly 20 feet, 20 meters. Left and right, it will come.
So,
it
20 meters.
My lord.
So that the proposed ordering process could have been
easily they would do no further compensations, and in certain area where alignment is required,
yes,
where they need to go.
These are all developments which took place prior to the issuance of any notification under LA.
Yes, under Section 11.
Yes. So, which way, like, you see, like those facts.
Yes.
Has a bearing in this case.
My lord.
Now, so far as you are concerned, what happens after the initiation of the proceedings? That is what matters most.
Now, therefore, I just narrate the background. Therefore, Lordship has put the query that there was a background whether that will support my case or not. Now, I'm saying submitting that they have done this homework behind under Section before Section 11. Now, this homework was the sole basis for issuing Section 12, Section 11. Now, when they issue Section 11, they have removed the 35 feet from both sides. And whatever areas, a few areas where they need further areas for...
What do you say by, what do you mean by removing?
They exclude. They exclude 35 feet from both sides. 35 feet from both sides.
Section 11 contains the detail of the...
detail of the land, mentioning our names. But wherever our names is there, my lord, I have a plot here. Now, they have taken away 35 feet from center line, and still they need some more land for the expansion. Therefore, they add another 1 to 3 meters. Then in that 1 to 3 meters, that yes, Mr. Shengreso, this is your land. Under Section 11, we are issuing this. If you want to file any objection, you can file. This is the object of the act, the action of the collector.
Then you say that your land is beyond that 1 to 3 meters.
Right. And I'm saying that, no, you're wrong. My land is not only 3 meters. My land is much more than that. Much more than that. Now, they have done this. Now, therefore, the requirement of Section 15. My lord, because the Lordship, the Section 15 is a mandatory provision, my lord, that would be the basis for the state government to take a decision.
Section 15.
15, my lord. Of the new act.
Yes, definitely. This is proceeding under new act.
New act, madam.
So you do not have to refer to old act.
Yes, madam. Section 15, my lord.
Section 15 is equivalent to Section 6 of the previous.
Section 5A of the earlier. 5A.
5A, objection.
Yes, objection in hearing.
And what is Section 16? Section 19 is the equivalent of Section
6.
16.
Section 6.
Yes, Section 15. Hearing of objection.
My lord, if Lordship permits me, before reading Section 15, my lord, if I take Lordship to Section 15, Section 11, that was the preliminary notification.
But that means that is Section 4.
Yes, that is Section 4.
Yes.
After Section 4, now Section 11.
Yes.
Now, Section 12, Lordship, you kindly see. Section 12. I'll not drop it to Section
You
11.
have taken us to Section 11. Now you're skipping Section 11 now.
But no, Section 11 preliminary notification was
from
issued.
Section 15 you took us to Section 11. Then now Section 11 also you're skipping.
My lord, I want my lord to travel
Is it something that
sequentially.
you just start reading and find that is not in your favor and then you go to jump to somebody?
My lord, this Section 11 favor both the parties, my lord. My lord, I'm just, my lord, trying to explain, my lord, submit. The Section 11 pre-notification was issued. They're mentioning my land and others. And now, Section 12, Lordship, kindly see. What is the mandatory provision of Section 12? Now, preliminary survey of land empower our officers to carry out survey. For the purposes of enabling the appropriate government to determine the extent of land to be acquired, it should be lawful for any officer, either generally or specifically authorized by such government in this behalf, and for this servant and workman to enter upon and survey and take levels of any land in such locality, to dig or pour into subsoil, to do all other acts necessary to ascertain whether the land is adapted for such purpose, to set out the boundaries of the land proposed to be taken, and intended line of the work, if any proposed to be made thereon, mark such levels, boundaries, and line by placing marks and cutting trenches, and where otherwise the survey cannot be completed, and the levels taken and the boundaries and the line mark, to cut down and clear away any part of any standing crop, fence, or jungle, provided that no such act under clauses A to E in respect of the land shall be conducted in the absence of the owner of the land, or in the absence of any person authorized in writing by the owner. Lordship, kindly keep in mind. Provided further that the act specified under the first proviso may be undertaken in the absence of the owner, if the owner has been afforded a reasonable opportunity to be present during the survey by giving a notice of at least 60 days prior to such survey. Provided also that no person shall enter into any building or upon any enclosed court or garden attached to a dwelling house unless with the consent of the occupier thereof, without previously giving such occupier at least 7 days notice in writing to this my intention to do so. Now, my lord, what happened in this case now? Now, Section 11 is a preliminary nature. Whatever land they mention, he has to mention that in this area, we need to acquire for expansion. Now, to ascertain whether that plot they mention under Section 11, to what extent they need to acquire, what is the nature, whether it will really serve the purpose or not, they have the power to enter into the area, mark it, cut it, whatever. Now, to do that one, the law is very clear. You cannot, collector, you cannot enter the land of the citizen without and conduct survey without his present. Number one, first proviso. And in case if he is not present, you must ensure that 60 days notice, prior notice before conducting survey. You give that one. Then in day only you can do. That is the position. Collector is silent. He admitted that he did not fulfill that one. Now that is the section 12. Then, my lord, social impact assessment.
Why you have referred to Section 12? What is your submission with regard to Section 12?
Madam.
Do you want to say that no notice was issued to you?
Yes, yes. That pleading was exactly.
Now, just one thing. Before you proceed further, this court will ask a question.
Yes.
See, Section 12 basically authorizes the government.
Yes.
If they require
yes.
the determination of the extent of land to be acquired.
Yes.
If any determination is needed.
Yes.
By entering those areas.
Right.
Now, if government can determine
yes.
the extent of land
right.
to be acquired
yes.
without undertaking any of the exercises mentioned in subclause A to E,
right.
then what is the question of issuing notice?
My lord. Here, if the government say that we are not acquiring none of your land, we
no,
are.
They will acquire.
Yes.
See, Section 12 is for the purpose of determining the extent of acquisition, the extent of land required.
Land mentioned in the
now,
Section 11.
Supposing without undertaking any of the exercises.
Yes.
As specified in subsection A to E.
Yes.
Government is in a position to determine
yes.
the extent of land
yes.
to be acquired.
Yes.
Then where is the question of issuance of any notice to you?
My lord, if the government, my lord, consider that the private land is not required, we are doing the expansion.
Yeah, this question is not that. The question is not that the private land is not required. See, The simple question is that, you see, that it means now the exercise, which are the exercises which are mentioned in subclause A to E.
Yes.
Must have to be undertaken in order to determine the extent of land required. So without undertaking those, it is not possible to determine the extent of land.
Exactly.
That is the answer lies there.
Yeah, that is the intent. That is the intent of the statute.
Means like government will not be in a position
yes.
to determine the extent of land.
Yes, madam, correct.
Yes.
Because once they travel to section 19, whatever the land mentioned to mention in the section 19, that is the final area of land to be acquired. Therefore, before they do that one, collector need to determine the extent of the area to be acquired. And now they have mentioned my name under section 11. Therefore, they know very well that they are going to take part of my land. Now, how they determine part of my land without giving me a notice?
Under section 12.
Under section 12.
So no section 12 notice.
No section 12 notice.
Your name is under section 11. Your name.
It is there. It is there. But survey also done. Survey, in fact, done by the NHITs here, as per the record, not by the collector. That I'll come to that point also. NHITs here is nobody to conduct a survey.
None of the petitioners have received any notice.
No notice. No notice. The affidavit also, they are admitting that fact. They did not say that they issue section 12 notice, and these are the notices they receive. It is not. Now thereafter,
what is the consequence if that notice is not served?
My lord. Therefore, my lord, I'll come. Now, this is the, my lord, they have done section 12, and now the importance of adhering to section 15 comes into picture. Now, section 15, where, my lord, the landowner has the opportunity to place their case. Let's see, you are not issuing me section 11 or section 12 notice also. You are not conducting survey in my presence. How you ascertain my land? In section 11, you mentioned 3 meters. My land, how you determine that 3 meters, you determine this is incorrect or this is correct. Therefore, the window is open for the landowners to place their matter before the collector under section 15. How important it is therefore the section 15. Now, Lordship, section 15, let us, my lord,
yes.
To give Lordship permission to together. Hearing of objections. Any person interested in any land which has been notified under subsection 1 of section 11 as being required or likely to be required for public purpose may within 60 days from the date of the publication of the preliminary notification object to, which is important, object to the area, the ground for objecting area. Now, I cannot bring all the issues before the collector. There is a specific identified subjects which I need to bring before the collector. Now, I have the right to object with regard to area. Now, the area, my lord, they say that no, I need only 2 meters. Then I have the right to say, how can you, my land is not only 2 meters. It's a 10 meters you are taking away. You are forgetting my 8 meters. So he has the right to object this. And then he has the right, when he has that opportunity, he may raise the question of ROW also. That ROW issue could have been resolved at that point only. Suitability of land proposed to be acquired. Justification offer for public purpose. I don't need question for public purpose. Yes, it is for public purpose. We have no oppose to the public purpose. Development we are welcoming. Findings of social impact assessment report. Now, every objection under subsection 1 shall be made to the collector in writing. And the collector shall give the objector an opportunity of being heard in person or any person authorized by him in this behalf or by an advocate, and shall, after hearing all such objections and after making such further inquiry, if any, as he thinks necessary, either make a report in respect of the land which has been notified under subsection 1 of section 11, or make a different reports in respect of different parcels of such land to the appropriate government, containing his recommendation to the objections. And it is important, my lord, is how government is to be very careful about this, which objections, together with the record of the proceeding held by him, along with a separate report giving therein the approximate cost of land acquisition. My lord, Here, collector has to specify, my lord. It will be a huge exercise financially. He has to place it, my lord. And that will really opening eye-opening for the government to take conscious decision. Particulars to the number of affected families likely to be resettled for the decision of the government. The decision of the appropriate government on the objections made under such shall be final. Now, therefore, now this objection is so crucial that after hearing the interested person, collector will be very particular about this and place the entire objection of the landowner and send to the government, because collector is not authorized to take a final decision for acquisition. When the collector, my lord, placed the entire report along with the cost involvement, along with the nature of objections, this report of the collector is the sole basis for the government to take a final decision whether they really need to go for acquisition or not. And if they deem fit that yes, we can still go, cost is there, my lord, we have seen the objections, still we have to go, then they can go under section 19. Now what happened in this case, my lord, the grievance is that this important factor, my lord, the entire grievance of the landowners was completely silent.
No.
And therefore,
did you file any objection?
Yes, we filed an objection.
You filed an objection.
Objection.
On the petition.
Yes, objection.
This is on record. The government is not denying that.
But they are not denying. Collector has filed his affidavit.
So your objection was filed, but then that has not been dealt with.
Yes.
They have not considered your objection.
My matter. Now under the Act, if I understand this provision properly, then he has to see my objection, petition in writing, and then he has to give me opportunity, and he has to record my nature of objections, and my nature of objections, which he has recorded, will be forwarded to the government.
The government has not taken any decision on the basis of your objection. Do you want to say that?
Exactly. Without hearing how the government will take decision.
No. Whether there is no, see, whether they have heard you or not, that is one thing. Is there any order in the form of a decision under subsection 3 of section 15? Is there any order in existence?
My lord, I'm not aware. I'm not aware, my lord. I'm not aware. Here the record will show.
No order.
Yeah,
so that means their objection was not entertained.
No, it was entertained. It was looked into. I'll come to that. No, this is slightly.
The question is that.
Yes, sir.
If at all, section 15 mandates filing of objection.
Yes.
If at all any objection comes, then the government has to take a decision.
Yes.
The decision has to be in the form of passing an order, isn't it?
So that has been indicated in the section 19 notification. There's a clear specification there that the objection under section 15 have been considered and heard.
So now you want to say that section 15.3 does not mandate passing of a separate order.
I have some authorities on that, my lord. That the incorporation of that in section 19 itself would be sufficient.
What these authorities say?
That a specific order is not necessary. No. Not necessary.
No, see,
the satisfaction has to be indicated somewhere, so it is indicated in the section 19 notification. That is the most important thing.
You have to make this court understand about
yes,
the law.
Yes.
Okay.
I may be wrong, but
see, like, go by the general reading.
Yes, Lord.
And which way it is to be interpreted, that is what you see, like this court will seek assistance.
Yes, Lord.
Yes. Well, so according to you, Mr. No's decision was taken, nothing. So your objection under section 15 was not considered.
Yes.
And now, where is your objection?
My lord, I'll come to that, my lord. Had my lord entertained the objection, my lord, objection in writing is one thing.
No, we can record that your submission is that you filed the objection, it was not entertained.
Yes.
We'll just
go
by, because we have to make up for your submission, note of your submission.
Right. Therefore, my lord, had the collector granted this opportunity and heard them, recorded the nature of their objection, and placed the entire objection to the government with regard to, my lord, ROW and others, the government could have perhaps, maybe in one way, arrive at a different decision, that we had the ROW is not incorrect. There was no history of acquisition by us, PWD and others, existing road also. And the district council, the nature of district council letter also did not.
So, Sangesh, you are going to the merits in which manner more Now, see, here, where in a read application, we may not go into that deep depth of the thing. What this court would see whether there was an objection filed by you or not.
Yes.
And whether it was decided by them.
Yes. I'll come.
Which manner it should have been decided and which not. That is not the question of the writ. This will not exercise the jurisdiction of an appellate.
Therefore, I'm submitting that the section 19 declaration issued by the government without perusing the records of the objection and the nature objection recorded by the collector.
See, do you want to say that what is your submission? You want to say that your objection was not decided?
Yes.
Or it was not decided by taking into the contents of the objection, taking into consideration the contents of the objection. What specific your submission is? Because this is vital for
yes.
in a writ court.
Right.
If you want to say that the grounds of objection were not considered while deciding, that will fall under one category of submission.
Different category.
And if you say that at all your objection was overlooked, it was not at all considered.
Yes.
Then it will come under another category.
Another category.
So
correct.
What your specific submission?
My submission is second. My contention is that, my lord, Section 19 declaration was issued without at all hearing or examining the objection in writing, and in the absence of the hearing of the parties.
So it is not your case that no decision was taken?
No decision at all. My lord, without hearing me, how they will take a decision?
No. Now, kindly to say that there exists no decision. Whether a right decision or wrong decision, this is not the question.
Yes.
To say that there exists no decision and to say that there was no proper decision are two different things.
Right.
Now, what your contention is?
No, my contention regarding this aspect, twofold.
Do you want to say that there was no decision, or you want to no proper decision?
There is no decision. Number one, because naturally, in the absence of the hearing,
so it means
they cannot take a decision.
Objection was not at all decided.
Yes. There is no decision.
Yes.
Under subsection, my lord, subsection 3 of section 15.
Yes.
And secondly, alternatively, my lord, even if any decision taken by the government under subsection 3, in absence of hearing me, that also illegal and invalid.
That will not be rendered as a decision under.
Yes, exactly.
So that means your argument is twofold. One, you say that it is not decided in terms of section 15(3).
Yes. And
second thing, that if at all there is any decision in existence, this decision was made without hearing.
Yes. So it
means once a decision is made without hearing you, that cannot be regarded as a decision.
Yes. Correct. And on the basis of decision,
just a minute. Yes, please.
Therefore, on the basis of, my lord, here before the government, whatever government has taken a decision, that decision of the government is the basis for issuance of section 19. Now, the government, without taking any decision under subsection, my lord, subsection 3, government cannot issue section 19. Because section 19 is a declaration, publication known to the public only. The basis for the government to issue section 19 is the decision which conscious application of mind they have done under subsection 3 of section 15. And that decision, whatever they have taken, in absence of hearing of the parties or objection, records from the collector, is absolutely nullity in nature. And now we may travel to section 19. So, my lord, we have completed section 11 and section 15.
Yes.
And admittedly, the pleaded case of by the collector also, that
your contention is there is no adherence to section 12.
Yes.
Non-adherence to section 15.
My lord.
Subclause 3.
Yes.
And these are all mandatory provisions.
My
So once any proceedings of acquisition takes place without adhering to those mandatory provisions, this cannot stand in the argument.
Yes. And with regard to section 12, collector completely silent. He did not take the plea. Then I issue section 12 notice.
But the section 12 is a mandatory. Still now there remains a question in the mind of the court. If you see this section 12, It is basically the kind of, permitting the government to enter and do the needful things for determining the actual area of land to be acquired. But then, if at all, does the law say that that is a must before the acquisition? See, if you see by the language, section 12, the start of the C, this is a provision which enables government to enter into a private. Of course, after fulfilling the requirement which is narrated in the provision.
Right.
But then, does it mean that the section 12 has to be, you see, like undertaken if there is no need?
Why not?
Say there is a flat land, plain land. It's a ground. Okay.
Yes.
Now one can assess the land by standing from far distance. Doesn't have to go inside.
Right.
And then say, like, we do not know. These are the questions which come to the court. Mine's court. Court may be wrong.
Right.
So it may happen like that no entry is required to a private land. Now it is only how much area to be taken.
Yes.
Now that is also, you see, like, not required. This is only the measurement to say.
Right. Now,
so there may not be any survey as contemplated in section 12.
Well.
Now, whether this is conduction of survey is the precondition for proceeding with the acquisition proceeding.
Madam, it is required to be ascertain, yes.
And if in absence of section 12, no proceeding cannot be held.
My lord.
Is it your submission?
My lord, this will read together with the section 11, section 21. We'll come to that portion also. Now, lordship will say that the entire land is a plain area.
So supposing.
Now, supposing. Now, if the government wants to acquire certain land, certain feet from my land, my lord, government is entering into the territory of a private person. So therefore, the statute provides that you shall, it says, first provision.
Government is not entering. Government is deciding only how much is to be taken.
That is true.
The survey is required. You see, when supposing the government cannot determine how much is needed. Now, if something can be determined without entering your land.
My lord, the issue, my lord, therefore, if that be the case, my humble submission is that statute would be providing different way. But the statute says the moment you are entering into somebody's land, how do you determine without survey?
See, a moment you are entering, whether then entry is mandatory or not, that is what the court is asking.
My lord, this proviso is very clear. Shall, it says, my lord, in respect of the land shall be conducted in the absence of the owner.
No. You see, if you start from section opening line of the section 12.
Yes, for the purposes
for the purpose of enabling the appropriate government to determine the extent of land to be acquired.
Yes.
It shall be law for any officer, either general,
yes,
authorized only, and for servant,
yes,
and workman to enter up.
Yes, enter upon and survey.
Lawful to enter up.
Yes.
But then doesn't mean that he must enter.
No, my lord. Therefore, without entering into my land, how they will determine the area of the.
So that is what I am saying.
My lord.
That survey,
yes,
as contemplated in section 12, yes, is mandatory.
It is mandatory
before acquisition is taken.
My lord.
Now that is what you want.
My lord.
So it means without a survey. Now, if you say that survey is conducted,
yes,
but then not strictly in accordance with section 12, because the entry of the officer was not required for conducting a proper survey. Now, even that case also is needed.
My
it
lord.
means the survey will include the measurement of land. Yes. But then clause A2E doesn't say about the measurement of land.
My lord, survey, my lord. Provided that no act under such respect of shall be conducted in the absence of the owner of the land. Now they enter into conduct survey, take or board, my lord, marking. My lord, they are marking which land.
Survey is conducted.
My lord.
Then only the question of marking comes.
Marking comes. Well, when they conduct survey, in the area, the question of ticking come, question of marking come.
So it is mandatory.
Yes.
So it is mandatory. Section 12 is mandatory.
Yes.
In no situation it can be avoided. It can be bypassed.
My lord, if they want to take my land, my lord, they have to follow this.
Yes.
My lord, that is my. So collector is silent about this. they admitted. And section 15 in their affidavit, they say that no, we have issued section 15 notice also. I will take the lordship those materials. But non-adherence to section 15 in the affidavit, it says, will not invalidate the acquisition process because they are participating. Writ petitions are participating in the acquisition process. I'll take the affidavit later. Now, para 9, subsection section 19. My lord, I don't need to read section 19 declaration. My lord, with lordship permission, may I read section 19, my lord, since I challenge section 19 declaration.
See, any reading which will throw more clarity, please undertake that.
My lord. My lord, section 19.
You may have to come across some very elementary questions which may surprise you, but then helpless. You have to address it.
My lord, subsection 1. My lord, when the appropriate government is satisfied, my lord, may I pause for some time? This satisfaction comes after my lord, he has seen
Report.
the report, the collector report.
Report means that decision.
Yes, that decision.
That 15.
Yeah, the 15.3 decision. After considering the report, it says report also, my lord. This is the report of the collector.
Yes.
No other report, if any, made under subsection 2 of section 5. Is very.
Now, that is the question.
My lord, if required. Now the report is with regard to, my lord, when we see the section 5, is not with regard to the objection alone. It's with regard to other, cause other, my lord. Section 5, that any particular land is needed for public purpose, a declaration shall be made to that effect, along with the declaration of an area identified as the resettlement area for the purposes of rehabilitation and resettlement of the affected families under the hand and seal of the Secretary of such government or any other officer duly authorized to certify its orders, and different declaration may be made from time to time in respect of different parcels of any land covered by the same preliminary notification, irrespective of whether one report or different report has or have been made whenever required. Now, the collector shall publish a summary of the rehabilitation and resettlement of the scheme along with the sons. It's not done. Provided no declaration under this subsection shall be made unless summary of the rehabilitation and resettlement scheme is published along with the such declaration. Provided further that, my lord, no declaration under this subsection shall be made unless the requiring party deposit an amount in full or a part as may be prescribed by the government toward the cost of acquisition of the land. Provided also that the requiring party shall deposit the amount promptly so as to enable the appropriate government to publish the declaration within the period of 12 months from the date of the publication of preliminary notification under section 11. In projects where land is required in stages, the application for acquisition of land acquisition itself can specify different stages for the rehabilitation and resettlement. My lord, I may not read further, my lord. Not read further.
These are all with regard to rehabilitation and all those things. So
yes.
It may not be very vital so far as this thing.
Therefore, my humble submission regarding this only.
It's only the opening part of section 19 which you want to
that is important.
That there has to be, after consideration, satisfaction has to be achieved after consideration.
Yes.
And in your case, there was no report.
My lord, the reason why, my lord, why government need to satisfy, depend on the collector, is that government cannot enter my land under the LA Act. Only the, my lord, the collector and the authorized, my lord, authorized person, they can provide the report, including my objection, including the cause of the land acquisition. And after the satisfaction only comes on the basis of those materials. Now, my humble submission is that this section 19 declaration in my case was done, whatever satisfaction is not based on the proper record, because there is failure of complying section 50 and section 12. So because of that, I challenge this section 19 also.
Yes.
19. And I may read before I go to the next year of the writ petition, section 20.
Yes.
Section 20 is also important. It says, land to be marked out, measure and plan, including making of specific areas. The collector shall thereupon cause the land unless it has been already marked out under section 12. Madam. To be marked out and measure, and if no plan has been made thereof, a plan to be made of the same.
So that is where the question of, you see, the mandatory nature of section 12 arises.
It has to read together.
It means if no survey is conducted under section 12, there still remains an opportunity for the collector under section 20 to mark the land.
Well, now there is no manual. Therefore, I read this one. Therefore, to substantiate that there is no record annexed in the writ petition.
Any reaction to?
No, I'm agreeing with Lordship. I'm agreeing with what your Lordship is saying.
Just do not agree just because it supports your case. No, I agree if it is legally correct. No, perhaps you see that is a question. This is coming up even still that there remains this thing. Whether how section 12 is how much mandatory. You see whether in any acquisition proceeding that survey under section 12 is a must. Even where cases say like it can be made out. No survey is basically is required to find out what is to be done or how much land to be acquired. Even in such cases also whether survey is mandatory or not, that is what.
In my limited understanding, as your Lordships have rightly observed, this is an enabling provision which authorizes the staff to go into the property and mark it. In case section 12 is not done, they can go to section 12.
Take your seat, it will not disturb Ms. Inner Counsel.
No. Well, therefore, this section 20 is clear. Now, if there is no survey under section 12,
yes,
then the collector is authorized, allowed to invoke this.
Something which has not been done under section 12 can be done under section 12.
Can be done under this. And the collector, my lord, did not make a vermin even in the affidavit that I did not do the survey under section 12. I have done the survey in the section 20. It is not used because admittedly, my lord, the survey was not done by him. It was done by the NHI this year. Even the parties put up an application RTI that please show us the survey conducted by you. He did not provide. In the affidavit also he did not. So whatever he is relying, the material was supplied by the NHI this year, PWD report and the district council letters. There is no independent survey done by the collector under this section 20 also.
No, what else? What ground? What more ground do you have in your case?
Now, my lord, therefore, section 21, my lord. Section 21 earlier occasion also, my lord, we have discussed this matter. Now, section 21 also, my lord. Now, collector is in the last week also. They are saying that we are offering land compensation to all of you. These petitions are adamant. They don't want to come forward and collect it. They want to create a chaos in the Karo Hills. They are the only one who doesn't want to cooperate with this. I offer the compensation. That is the submission of the respondent. And some of them.
How many of you have received compensation?
So, more than 30 of them received.
Just a minute.
Yes, just a minute.
Just a minute. Just one question is there. Now, there still remains to be a part of the district petition.
My lord.
Can person, those who have accepted compensation, still maintain their challenge to the acquisition proceeding? They maintain their challenge to the rate which they have received. But then can they maintain to these things? Estoppel will not come.
I don't know.
No, this is one hurdle you have to come across. See, according to this court, you cannot. Once you accept this compensation, you cannot maintain a writ petition praying for acquisition, praying for setting aside of it.
Right. Therefore, mainly, my lord, I am addressing, my lord, for the interest of the petitioners who did not receive compensation. Those who receive compensation.
Then others will have to be this thing. Others cannot remain a part of this writ petition.
But if Lordship deems fit, Lordship may strike out their name also. I don't have problem.
So who are the persons who have received?
But we'll identify, my lord. We'll keep the list.
We'll just say that this writ petition stand dismissed so far as they're concerned.
My lord, with regard to
Mr. Sen, if somebody received compensation, cannot maintain a challenge to the acquisition proceeding.
Precisely. That's what we were saying from the right
elementary thing. We cannot just
and
we do not need. Yes.
They have accepted it without any objection. So now the land stands vested with the state.
Comes, then it will be a question under section 18 or 13 or whatever it is, section 76 and whatever it is. But then there cannot remain any challenge to the acquisition.
Yes, the land stands vested with the state now. So as against them, these proceedings will be termed as final and concluded. So I have the list of the parties who have already received compensation.
Concluded not so insofar as the rate is concerned.
No,
But
that's a
that will be
different issue.
separate cause of action. This court has
Yes,
nothing to do. with
they
that.
can pursue it under 64.
Only thing is that this court is concerned about the things. Then basically, Mr. Sangresh, so you should have filed an application for striking out their name.
My lord,
No, you could not have maintained this writ petition by keeping them as party here.
my lord may strike out their name also. My lord, whatever information, my lord, all of them are not giving me the instruction. Some of them. So this some of them is collecting information from the rural areas. Now, who has exactly received or not, collector record will show. And I have also received information.
Have information, they are your clients.
My lord, therefore I have
Your
received information.
submission will be more reliable than what the collector says.
My lord.
If it comes as your admission, that is the most dependable piece of evidence.
My lord, I prepare those who are received, subject to the records.
You should have given at the beginning. You see, Mr. Sangresh, we have proceeded so much with this case.
But Lordship,
But
may I
with full interest.
just remind Lordships, this is a new submission being made today. On the last hearing, a completely different submission was being made by my learned senior. With all due respect, what was submitted earlier was that, irrespective of how many people have received their compensation, they can maintain the writ petition to quash the entire proceedings.
That is also there.
That was the submission on the first day.
That is also there.
That submission will be rejected at threshold.
Lordship.
That was to some extent highlighted. Lordship is not inclined to examine that aspect. However, my lord, the nature of the land, my lord, what the compensation has been paid is the.
Which part of the thing is not, this court is not ready to examine, Mr. Sangresh?
No, my lord, that is.
No, what submission, what kind of thing?
No,
See, so far as this court is concerned, if you have received compensation.
Yes.
From the acquisition proceeding,
yes,
you cannot maintain challenge of this because we are already beneficiary.
My lord.
So you cannot. This is not.
Lordship, that is the mind expressed by my lord. Now the nature of the challenge here is, my lord, the compensation is, my lord, paid for the land beyond ROW. And the challenge is with also regard to, my lord, including the land fallen with ROW.
You are going altogether going
therefore,
to separate thing.
My lord, therefore.
Now which area would fall under ROW or not, we do not know. It is not only a question of law whether that ROW, whether you are entitled for some compensation for acquisition of ROW or not. This matter is not now confined to that. In view of what you have said, it seems that even ROW is what is ROW also, that is disputed. According to them, one area is ROW. According to you, that area is not ROW. So these are disputed. So this code is not at all in any kind of confusion with regard to those aspects of
right.
Yes.
Right.
All right.
Okay.
Now, only thing is that this court basically was very much interested to know from you, once you had made a submission that this acquisition has proceeded without following the mandatory provisions.
Yes, that is the issue.
And you said that there is apex court judgment which says that in non-adherence to those things,
yes,
would make this acquisition entire this thing.
Yes.
Null and void.
Right.
Okay. Now
the list, my lord, I have given.
Only now
the latest instruction I received.
Now this petition number 457,
yes,
14, 23, 24, 34, 37, 40, 48, 68, 71, 82, 83, they have received. Yes. Partly or whatever it is, but then they have received. It doesn't matter whether in part or full. Once they receive, estoppel will come.
Right. Now the list I have submitted.
Then you will agree that their name should be struck off from the petition.
My lord, just a point on the top. Petitioner who have not accepted any compensation, their total is, my lord, 32. In the list, my lord, I've just applied to court master.
This is given by Mr. Shen.
Yeah, just now I submitted, yes.
This is a list given by?
No, I have given. I prepared. Yes.
Now you agree with that? There is.
I'll have to compare. I've not been served a copy of this one.
Mr. Shen, on the last occasion we told you.
I have a list. I have my own list.
Now, have you tallied it? Have you tried to
this
compare
list has been prepared just today.
You have received just now?
No, I've not received it as yet.
I can submit. It's a cross-check and will supply.
There is a lot of confusion with the names of the parties and all of this.
No, this has to be clarified. You see, we did not move under confusion. We did not pass any order in these things without getting these things clarified.
We can cross-check each other and clarify them.
32 have not received, 13 have received. Now all those 13 would be struck off. For 13,
My lord, in that list, for 32 not yet received, petitioner who have accepted the part full compensation on
then
civil
how come
structure.
it is 46, 45, 32 plus 13 is 45. Why you have corrected it as 46?
My lord, here one person was missing, 24 was missing in the list
So
by
then
typing.
you should have made the above 33 then. Instead of 32.
It should be 33, my lord. It should be 33, correct.
You have not corrected it properly.
It should be 33.
No, it should be 14.
Correct. 33. So these people, they are 33 not yet received. Now petitioner who have accepted part or full compensation on civil structures, not on land, trees, bamboo, etc., crops. My lord, 13 of them are there. With regard to land, they are not receiving anything, except the structure, my lord. So they are still...
See, the fact remains that all of the petitioners' names appear in the list under section 11, isn't it? Appended with section
19
11. So there is no question that they are these things. We are not going into those things, see, like who got what, whose land is what, or whose land is digged, whose land is not digged. We are not at all entering into those things. We do not want to, you see, like comma and all those things. The simple thing is here is that for seeking interference with the acquisition proceeding, you have to establish before the court that the procedure laid down
that is the issue.
has not been followed. As you are progressing right now, you have made those submissions.
That is the issue.
We will not even enter into the arena what is RW and what is whether it should be within 4.75.
Right. How many trees has been fallen?
We are simply saying that these are not the jurisdiction of the writ court to be undertaken in this petition. See, Lord, it is not to be undertaken in writ jurisdiction by this court. Now, if you say that the certain petitioners have received this thing, then you should file an application for this thing.
My lord, the parties are unable to come forward as of now because the things are the last week.
But then it is improper for you being a senior counsel to pursue a matter where they still remain a petitioner.
In fact, though there is scope for argument, but I am not advancing that one because they are not coming forward.
Sanglesha, you are senior counsel. It is expected that they will take care of this. It will cause a technical hindrance. You are representing all of them, isn't it?
Yes.
We cannot dismiss this writ petition for their default also because you are there to represent them. But then at the same time, if they have received compensation, you cannot pursue a case on their behalf. At least here in this petition, where you are seeking this thing, quashing of the thing.
So except 46, my lord, the rest of them appears to have received. And if lordship, my lord, I can take instruction and tell them to file a
this court has gone into the thing for so much things. See, after a few days, this court will forget the things. Your presentation was nice. Court was getting the things without much trouble. But then with this situation, we cannot proceed. Mr. Sen,
lordship may even strike out also.
Proceed. Though we have given time, but then until and unless these names are struck off, we cannot proceed.
Because I spent a lot of time trying to tally these names. It took me a very, very long time. And still there is a lot of issues here.
You can engage one of your juniors with you. Please find out and just see the correctness.
Yes, just to point out in this list itself, there is a mistake.
Mr. Sanglesha, you are not in touch with any of the parties.
My lord, some of them are in touch with me, my lord.
So then why don't you seek their assistance for filing an application?
My lord.
That's the proper way of doing things.
My lord. The problem, my lord, those who have received, they are not cooperating. They are not keeping in touch with us.
That is what the problem is.
So I have some difficulty. But anyway, my lord, I'll make an endeavor. Since I have invoked lordship jurisdiction, equity jurisdiction, honors lies on me. My lord, I'll take immediate instruction to file an immediate application for withdrawal. And my lord, I'll compare with the record of the collector where my referee is handling.
Please.
Comparing that one and file application for withdrawal regarding those people.
Striking of their name?
Striking their name. Remaining.
As per this permission to 49% they have
49% out of the now out of how many petitioners are there? 90. You, according to you, 49 have received.
49 already received. And
Mr. Sanglesha, please kindly peruse the list Mr. Devnath is holding.
Yes.
And he says it is from the record of the collector.
We will serve that same list. We have the same
We'll exchange a list and compile it.
If they say 37 number, they are not collecting that amount.
Their name, they are not collected.
They are not collecting.
Okay, if they have not, not collected, they can still maintain the challenge.
And then 3 numbers is they are having zero compensation.
Zero compensation.
Zero.
And
Means
one
they do not have, what is zero compensation? They do not have any land.
They are not.
Their land is, that means their land is not taken, only ROW is taken away.
Then land is not taken.
that
ROW
is-
cannot be taken. ROW is not yours.
Yes, that
So
is,
you
that is
cannot say
necessity
that it's
basis.
taken.
So you will see one
Mr.
person
Sanglesha is
you will see
something.
one person petitioner there. This name is not there in the list of the.
This.
Section 11.
We will, my lord, we'll exchange the paper, cross-check it, and
Kindly
finalize.
do the needful.
Yes. We'll do that.
Do not create this, keep this confusion.
And maybe post next week itself, my lord. Within this week itself, we will try to find.
Whatever these things, we'll just, if you can do it, we'll post this matter after 2 weeks. In the meanwhile, you just do it. If you do it early, then we'll.
Yeah, we will. Quickly, we'll do it quickly.
So you will
We'll do
see
it
here
quickly.
another problem is come up just interestingly. Due to the status quo we maintain, and problem has come up because some garbage is there, and if it is rainy season come up, it will be lots of problems, so it will stop. So
What
they
happened to the matter pending before the other court yesterday?
That is
It's
coming
coming
up tomorrow.
Tomorrow.
Wait for
So
some
interim
time,
will
Mr.
continue,
See,
my lord. 1 week will not. My lord.
No,
Heaven
we'll
will
have
not
it then
follow.
after 1 week. We'll have it after the 1 week.
Yes,
not
1
2
week.
weeks.
So you will see if the garbage is not allowed to remove, and then they will life of the city will be maintained.
It's a lame excuse. my lord. They know these risks, madam. They are supposed to know all the consequences before
Garment.
deploying a 19 pole
Only in
reserves.
respect of 2 petitioners here, 2 persons here. Or 2, oh, so there are many.
The status quo to be maintained as regard to this. That's the problem.
You maintain status quo.
Yes.
What is it?
So you will see regarding the remove the garbage of food. Otherwise, it will be danger for the life of the people.
No. Then they will start taking again, deploying 3, 4, 5 producers.
Then it will cause danger, mister.
Yes.
Because some garbage there and some what's the there's a garbage including the soil is there beside the road. So if it is not
Yes, Mr. Sanglesha, is it correct?
No, no, no.
Is
madam.
there anything life-threatening?
No, no, not at all. Not at all.
it is
They are the
I-
one who
I have
deploy,
sent a WhatsApp
who has
message.
done the digging.
He's saying there's nothing that's
So in such case, petitioners should take the responsibility.
No, we'll have this. Since you have made a submission, instead of 2 weeks, we'll have it after 1 week.
Yes, yes, we can do that.
That is the only thing. Or that is what the only thing. Yes, you have anything to say? You are yet to enter the battlefield. Yes.
So if let's say the incidentally any accident happen due to this, what is that?
That is
Because
any-
so it will come up in the
That
road
is
and after
sufficient.
that-
So what are the nature? Then you just tell me. You just cannot. Then you file an appropriate application showing us what is the situation. Tell us which way it is life-threatening.
because you look at this.
No. See, like you have. It has to be a part of record. You do not show us anything from there.
They've sent me.
This court will not see your mobile. We will not know whether this picture has come from where. We cannot. If you at all wanted this, you should have filed an appropriate application then. You should have been ready.
Exactly, exactly.
Just after hearing this matter at some length, it transpired that some of the petitioners have already accepted payment of compensation in relation to the acquisition proceeding, which is under challenge in this petition. The learned senior counsel appearing for the petitioner prays for grant of some time to file an appropriate application for striking out the name of the petitioners, those who have received compensation. Prayer allowed. Release this matter after a week. And in the miss case, in this there are 2 miss cases.
Yes.
These are there today.
Yes, madam. Should we
What
list
are
it
those
together?
miss case numbers, Mr. Sanglesha? Just say list this matter after a week. In the meanwhile, The interim order passed earlier shall continue.
Well, I hope the Lineage CGC may also exchange the relevant document to me so that I can verify.
Please, you do these things. You do not want. We do not need any judicial order for doing this.
Yes.
This much coordination is there. You see, here you may fight outside. You should have that much cooperation. You see, like which doesn't damage.
I've given my copy.
Persons which already have the comprehension, then we can do the job in that basis.
Let us ascertain that one without ascertaining.
What would status quo mean? You do it, they can do that.
Keep the approach.
So I will fair enough to file this case. Move to the garbage.
That is up to you. That is your liberty. We have not curtailed your liberty, Mr. Jamnath. You know it very well. If any interim order is passed, what is to be done, what is not to be done, you know it very well. You are a seasoned lawyer.
Hearing item number 3.
Yes, Mr. Mohan. You are there for the respondent.
Yes, my lord, it will take a long time. My lord, if it is posted after 2 weeks, because I have got some personal.
We do not have a long time left today, you see. Huh? We have quite long time till evening 4:30.
He told me some personal difficulty.
I've got some
Yes,
at 1 o'clock.
Mr.
The dismissal from service, yes.
This is a case of which year?
18.
So
I think
you
next
are
will.
out of service for.
Yes. And she.
You do not expect to get it back.
Because she already attained superannuation age, everything finished.
When she is superannuated, which year?
I think 2000. 33 years she had been in service, then maybe under 1 or 2 years, something like that was there.
She has superannuated after attaining the age of superannuation.
No, she was dismissed before that,
No,
before
that.
superannuation.
Otherwise,
she would have been. Otherwise, she would have been go on superannuation in the year 2020, if I am not mistaken.
Yes.
So it means if she is successful in this petition, she cannot be reinstated in service.
No, cannot be.
Only the service benefits.
Only the benefits. That part only.
Yes, Mr. Ichanath, Learned Counsel is appearing for the respondents. All the respondents.
All the respondents.
Please for grant of some time on account of his personal difficulty. Learned Senior Counsel appearing for the petitioner has no objection. The prayer held, list after 2 weeks.
I'll be blessed.
So old matters, we'll just try make an endeavor to finish it.
Yes, yes.
This court doesn't want to keep these old matters. You see, otherwise the court is ready to accommodate lawyers. But then old cases.
Next it will.
Creates a burden, and just if you see the size of
I
the
understand.
files, are unnecessary.
Me also reading same thing.
Then it becomes more difficult for the court and even for the lawyers. Even
I
to
know.
see like this.
I know we'll make an endeavor to finish.
Blessed.
Item number 9.
Yes.
But I spent a lot of time preparing that land acquisition matter yesterday. Can you accommodate me some? Give me some time.
This is matrimonial
matter. You can have it next week, my lord.
This is on that 200-202 issue.
Okay, it cannot be sent to mediation.
No, not necessarily.
That we have tried.
The matters which are possible, we will send it to mediation.
I don't think this will really help.
No, that is okay. If it is not, cannot be, then it's all right. But then otherwise, wherever the possibility is there, we will send it.
We tried our best to settle the matter outside court. Didn't work out.
The problem is with the lawyers. If the lawyers they settle it, then the matter also can be settled. You just say, Mr. S. Learned Counsel appealing for the respondents. Place for grant of?
Only on Tuesday, my lord.
Tuesday is what? Well, have it after a week, my lord. Tuesday.
After a week again, the same matter is going to come up.
Then have it after,
After
2
10
weeks, my
days.
lord.
After 10 days.
2 weeks, 2 weeks.
2 weeks.
After 2 weeks, we'll finish this matter, my lord. Lordship has heard this also earlier.
Time. Mr. Gautam Planet, counsel for the petition has no objection. Prayer allowed. List after 2 weeks.
Highly obliged.
Much obliged.
Item number 19.
Yes.
My lord, in this matter, I want to come and appear before your lordship physically.
Yes.
Can it be taken up day after tomorrow, your lordship, on 9th, my lord?
Who is the?
Because I have to place judgment.
So far the state is concerned, lordship only.
Day after tomorrow, my lord, I will come to my court, your lordship.
Only I would like to point it out, point out, your lordship, there is another case also filed by the private respondent here in your lordship. That is also that is a criminal petition number 40 of 2024.
Is it connected to this?
Lordship is
The petitioner is a party in that case.
lordship, yes. Let me just.
Petitioner is not party, my lord. Only this case.
You are not a party there, Mr. Goel, in that other matter.
Other no, my lord.
No.
Then we cannot take it together, Mr. July.
This is independent. Day after tomorrow, my lord. If not inconvenient to your lordship.
Day after tomorrow, yes. We can have it day after tomorrow.
My lord.
Yes, just the request of the parties. This is matter. Day after tomorrow.
Friday.
Then you give the date, huh?
Lordship, not on Friday, your lordship. I thought day after tomorrow is Thursday. On Friday, lordship. That will be on some other day.
Mr. Shulai has difficulty, Mr. Goel. You have to choose.
Then on 13th or 14th, my lord, August 13th or
13th or 14th also, how the situation will be.
Very lordship. Yes. Then
time for
after 16 any date, my lord. Date may be given then, my lord.
No,
it is convenient.
you verify it distinct from the things. We'll have it after 2 weeks.
Lordship, yes.
Just at the request of the parties, this is met after 2 weeks.
Lordship.
You verify, you just keep a contact with the office and then just because the list weekly list comes, so there should not be worried. So you will get the things.
My deeply obliged, man.
No other matter.